All right, here I am, Brendan Beery, with my friend Jeff Swartz. We are going to talk about what has happened in the Flynn case, the D.C. Circuit issuing a writ of mandamus. We'll talk about what all this means, directing the district judge, that's the trial judge, in the Flynn case to dismiss the charges against Flynn. Color me surprised. Not a lot surprises me anymore in the age of Trump, but I did not think the circuit court would go along with Flynn's lawyers on this. And so the first thing I want to talk about briefly, Jeff, is the role of Article III courts in our system of government and the unmistakable trend in our government. I would call it almost an infection or that is spreading that involves loyalty to a person rather than to an institution that we all know who that person is. So we've got the executive branch being stacked with people who are loyal to Donald Trump, being hollowed out of professionals and people with integrity. We have Congress refusing, as long as the president's party is in charge of one house, to act as a check on the president. And I think, and I want to ask you about your thoughts on this, John Roberts has a decision coming up here at a very macro level, whether he is going to allow the same contagion to infest Article III courts, so that the 200 judges whom Donald Trump has appointed sort of complete the task, right? There is now no check on executive power. Doesn't he have, I think he has a decision to make, whether he's going to start joining with the four liberals in more cases where executive authority at least is concerned, to put a check on this president.
Well, I think that clearly in the district courts there's been a large number of appointees. The real danger has not been the district court judges, but the circuit court judges. And in particular, surprisingly, at least only one of the two appointees in the Supreme Court has stuck with him through everything that he's really wanted to have happen. The judge who wrote the majority opinion in this particular case that we're going to talk about is in fact an appointee, a Trump appointee who had never served in a judicial position in the past. Her past is rather checkered in the context of the things that she has written about a lot of the major issues that she may face. She supposedly apologized for all of those, said whatever she had to say to get herself onto the D.C. Circuit, but still was only passed on a strictly partisan vote of 53 to 46. There was one Democrat who did not vote for whatever the reasons may be. There are clearly her two major opinions that she has written that we know about. The first one being her dissenting opinion on the majority, against the majority, who had basically upheld the congressional subpoena for the president's tax records. And this opinion, which somehow she got Judge Henderson, who's been on the court for a long time, surprisingly not senior. She's a 76-year-old jurist who is an active member of the court at this point, as opposed to being a senior judge. Got her to go along with this, even though she indicated very strongly in oral arguments, Henderson did, that she was in favor of allowing Sullivan to do what he had to do. In fact, she described Sullivan as being an old hand, meaning, he'd been around a long time, he knew what to do, he knew how to run his court. But she got Henderson to go along. Her opinion clearly is slanted against even the decisions of the D.C. Circuit. This is clearly a political decision she's made, a payback for the position that she has. She is the kind of circuit judge that will infect the judicial system, because the circuit courts make a lot of the law that we still follow today, that have never gone to the Supreme Court, because the circuits tend to start to agree with each other, and there's no reason for the Supreme Court to stick their nose into it. So it really is an infection. I was surprised by Gorsuch's recent opinion. I am not, and we've talked about this before, I'm not surprised at Roberts. I still consider Roberts to be a pragmatist. I still consider him at this point believing that he has to defend the court. the Chief Justice has a responsibility beyond the responsibility to just vote like everybody else. He decides who writes opinions. He decides many of the cases is supposedly be able to control the flow of the work and possibly control the flow of the way that people vote. And I think Roberts is one of those people who is going to come to that flexion point that he's going to have to decide, who am I? Am I the Chief Justice of the United States Supreme Court, or am I an ideologue? And I think that he's clearly indicated that he really tends towards the pragmatism and the protection of the court. So we really have to put our faith in him for the time being.
Yeah, I think that's true. It's amazing how many times the Chief Justice is in the majority. I was reading about that the other day. He's the vast majority of time he votes in the majority. But of course, that's because his vote is so often decides which side is the majority. So,
well, that's correct.
Yeah.
It's very much like Kennedy. Kennedy was in the majority so much of the time because he was the vote that made the decision. And I think that that's the role that I think Roberts sees himself in right now.
Right. So let's talk about the Flynn case a little bit. Before we get to what the machinations here of what the court has ordered and what is a writ of mandamus, let's make the point that there is hope for those who are still rooting for the rule of law because of something called an en banc hearing, which has not been ordered yet, but you have litigated and actually won in an en banc hearing setting, so you're a good person to ask. What is an en banc hearing? Because people say, well, hasn't the district court, I'm sorry, the DC Circuit, hasn't it ruled? Well, it has, but what can happen from here?
Okay, one has to understand that in 99% of the cases, 99.9% of the cases, there's a three-judge panel that basically represents the entire court, all the members, all the active members of the court, not the senior judges, but the active members of the court, when they make a decision. And in 99.9% of the cases, the court as a whole will stand up for that decision and follow that decision and adopt it themselves. They may chip away at it, but they adopt that decision. When a panel makes a decision, that is a three-judge panel, if there is a majority of the members, active members of the court, who don't like that decision, who think it's wrong, okay, and they don't want to have to follow it in the future, and they don't like the precedent that it sets, any one of the members of that court, on their own, sua sponte we call it, or even upon motion filed by the losing party, may grant a hearing en banc where there may not be an actual oral argument, but the judges now sit down in conference and they decide among themselves, okay, whether they want to follow it or not. In this particular case, there are presently 12 active sitting judges in the DC Circuit. If 7 of those judges don't like what happened in this case, and I can guarantee you Merrick Garland does not like what happened in this case. He is, right now, he is running around that court trying to figure out if he's got 7 votes.
And he is the chief judge of the circuit who was denied a seat on the Supreme Court by Mitch McConnell.
That is correct. And so he's running around this court right now, I'm sure trying to find out if he's got 7 votes. And if he has 7 votes, he may sua sponte order an en banc hearing, or I have to believe that one of the parties representing the respondent, and the respondent is the judge, okay, one of the parties representing the respondent in the mandamus action is going to file a motion for a hearing en banc. And if that happens, I think it's going to be granted. And then if it's granted, it almost guarantees that the ruling of Judge Rao will be reversed.
Right. So now you mentioned mandamus, so that's a good segue. The court issued a writ of mandamus, which is an extraordinary remedy that is supposed to be used rarely, which of course the dissenting Judge Wilkins, pointed out. What's the difference between a writ of mandamus and a direct appeal?
Okay, first thing, well, first of all, let me just say this. When you start talking about mandamus and or prohibition, you are talking about what's called extraordinary writs, and they're called that because they're only used for extraordinary purposes. The difference between mandamus is an original action filed before that court. It is not an appeal. It's a lawsuit that is filed above the court that you're trying to mandate or prohibit, a lawsuit filed against the judge by a party who feels aggrieved by what the judge has done or has refused to do. And as a result of which, basically it's a lawsuit by the defendant in this particular case, Mr. Flynn, against Judge Sullivan, asking for a writ, a ruling, an order from a higher court saying you must do the following. You are mandated to do the following, which is different than an appeal, which is filed by the losing party and you file your briefs, and there may not be an appeal of right. There may be an appeal of right here to the United States Supreme Court because every party has the right to one appeal. And if that's the case, they may be entitled. It may not even be certiorari. It may be that they can file a notice of appeal, but first they'll have to get a stay on this order. If they get a stay on this order, then you're going to know they're going to get cert, and if they get cert, the Supreme Court's going to ultimately make this decision.
Right, which goes back to our first point. We'll see where Roberts is on all of this.
That is correct.
Now, on the substance, the issue in Mandamus was whether the judge had discretion, the trial court Judge Sullivan had discretion under a rule called 48A to supervise this case in a way that, he didn't have to let the prosecutors withdraw, that since we have an actual plea. So what's Rule 48A? What did the court rule, and how did they get it wrong?
Okay, 48A is a rule of criminal procedure, federal rule of criminal procedure, that basically states that the prosecution may at any time file a motion to dismiss an indictment or an information, and it shall be granted or can dismiss upon leave of court. Now, the interpretation now is, what is leave of court? The first thing I have to say is, if it was just solely an executive branch function to dismiss the indictment or information in this case, then there would not need leave of court. So the rule was written to give the court supervisory power over this kind of decision. Now, generally speaking, those motions are supposed to be granted, except for where the court determines it's not in the public interest, it is not in the interest of justice to go along with what the prosecutor wants to do. And that's basically the level that they are supposed to consider in whether they should grant that motion or not. And of course, Flynn isn't going to object to the case being dismissed, but the judge apparently had some difficulties in light of the fact that it had been pursued so vehemently in the past. And he had entered a plea twice to the same charge. Okay, he had admitted on 3 other occasions that he was guilty, all under oath. And he's wondering why all of a sudden the prosecution's saying we don't have enough evidence to convict. Obviously, the defendant thought there was enough evidence to convict him. Okay,
right.
And so under the supervisory powers of the court, they look out for the public. They look out for the people in the context of making sure the prosecutor's doing their job without interfering with the prosecutor's job. That's what happened here.